Okay. Hello, everyone. Good morning, good afternoon, good evening. I think we are ready to start. Many thanks to all of you that have joined today this dialogue on behalf of the EU Cyber Direct, EU Cyber Diplomacy Initiative, together with the European Commission and the European External Action Service. I welcome you to this online dialogue on the UN Cybercrime Treaty negotiation. I am Nadia Barmpaliou, non-resident expert of the EU Cyber Direct project, and will help moderate today's discussion. We are quite happy to see such interest from many stakeholders. Just to start with a couple of logistical points, the meeting is recorded, as you've seen on your pop-up message, and live streamed. So if you wish to stay on, please stay with us and keep your mics switched off until we go to the discussion phase. To set us off, I just want to take a minute or so to set a bit the scene as we consider the timely moment to connect with all of you as the UN Ad Hoc Committee to elaborate a comprehensive international convention on countering the use of information and the communication technologies for criminal purposes, AHC for short, convenes for its second section as of next week and throughout to 10th of June. And it has quite a demanding task, this session, to discuss general provisions, criminalisation, procedural measures, and law enforcement provisions. And this is the stakes are quite high, obviously, as we are seeing this as an opportunity and the possibility to save the international criminal justice cooperation in the digital era. And part of this process, especially for the EU, is the meaningful participation of diverse voices from the multi-stakeholder community and incorporation of their input in the discussion. So the event today is really, on the one hand, an opportunity for the EU to present its views and elaborate a bit more on the submission it had for the second session, and we'll have the European Commission and Dan Rothenberg, Deputy Head of the Unit Security in the Digital Age from DG Migration and Home Affairs, to get us through that, and then have a certainly different perspectives from three different discussions. Paulina Gutierrez, Senior Legal Officer from Article 19, Nick Aston-Hart, Special Advisor on International Interim Policy at ICC United Kingdom, and Dr. Nena Ifeanyi Adjufo, Senior Lecturer in Law and Technology at Swansea University, and also Vice Chair of the African Union Cybersecurity Experts Group. Without further ado, I want to give the floor to Dan, and maybe note that after this initial reactions from the discussions, we will open the floor for an exchange of views and a dialogue with all of you. So we're very keen to have you here and for you to take the time to join us. Dan, the floor is yours.
Thank you very much, Nanya. I'm very grateful to have this opportunity to present the EU position, as you said, but also interact with those who have joined us today. The EU is very much looking forward to this second session of the UN Ad Hoc Committee, which will be, in fact, also the first session of negotiations on substance, during which, as you said, the first three chapters of the future Convention on Cybercrime will be tackled. So you mentioned it, the general provisions, the ones on criminalisation, and the ones on procedural measures and law enforcement. So, I mean, as you know, during the process which led to the launch of those negotiations, the EU has always insisted for ensuring an inclusive process, and we therefore welcome very much the fact that UN members from all continents submitted 29 contributions in view of these second sessions. That means that this inclusiveness is certainly there. There will be many voices heard during this process. The EU also shares, obviously, the concerns expressed by many UN members about the rise of cybercrime and the need to strengthen international cooperation in order to fight efficiently those crimes who are, by nature, very often transborder crimes. The EU also strongly believes that when it comes to fight crimes, strong conditions and safeguards must be agreed so as to ensure the highest possible protection of human rights and fundamental freedoms. Finally, the EU is also fully aware of the very short time frame under which we have all agreed to work, i.e. to finalize the negotiations by 2024, which is literally tomorrow when we talk about international negotiations. The EU therefore believes that UN members should focus on the elements where a broad level of convergence can be reached relatively quickly, leaving out provisions that are too controversial. So these are also the reasons why the EU inspired itself from existing, tried and tested international instruments, namely, obviously, the Budapest Convention on Cybercrime, which beyond the 66 countries who have ratified this convention, has also inspired more than 100 countries in the world for their domestic legislation, but also some UN convention, and obviously the UN Convention on Organized Crimes, UNTOC, and the UN Convention Against Corruption, UNCAC. So the EU wants the future UN Convention to be compatible with those existing instruments, as well as with international human rights standards. So let me now present you the EU contribution and enter into a bit more details into its rationale. So first, for the general provisions, for the reasons I've just explained, i.e. our collective commitment to act quickly and the need, therefore, to focus on the elements which can be consensual, the EU believes that the purpose of the future convention should focus on one hand, the prevention, investigation, and prosecution of cybercrime, on the other hand, on the promotion and facilitation of international cooperation, subject, as I said, to strong conditions and safeguards that ensure that highest possible protection of human rights and fundamental freedoms. We also, of course, agree that the Convention should ensure a high level of protection of victim rights and support for capacity building and technical assistance in the fight against cybercrime. We should, we believe, on the other hand, avoid regulating matters relating to cybersecurity in general. We should avoid rules on entering into rules on internet governance, and more generally matters related to or regulating national security or state behavior. Finally, the future convention should be clear and precise, and in the interest of time, again, focus only on the essential elements of criminal justice and the associated mechanisms for cooperation. So for those of you who have looked at the EU contribution, when it comes to criminalisation, perhaps there were some surprise there. It is in fact with the same logic that the EU contribution focuses on the criminalisation of offences that can only be committed using information systems, i.e. the so-called cyber-dependent crimes. So illegal access, illegal interception, illegal data interference, illegal system interference, and misuse of devices. The fact that the EU contribution does not include any cyber-enabled crimes, not even the ones that are in the Budapest Convention, so the offenses related to computer fraud and forgery, the sexual exploitation of children online, and the infringement of copyrights and related rights, Does not mean, of course, that the EU is not ready to include any of those cyber-enabled crimes in the future convention. But we believe that there should be a logic when it comes to define crimes in that convention. And our suggestion would be therefore to avoid starting a discussion crime by crime, which would be endless in view of the long list of crimes that have been tabled by many UN members. We believe that such a discussion would end up simply nowhere, and again, we are under some strict time constraint. So instead, our proposal would be that we frame the debate by discussing the criteria on which we could collectively agree for a crime to be defined in the future convention. On the EU side, we believe that among those criteria should be included, first of all, the fact, should only be included crimes which are universally recognized as relevant offenses. So, for instance, pornography does not meet that criteria, obviously. We believe that for a crime to be included, the use of information systems should substantively change the characteristics or the impact of the offense. So not, the mere use of an IT tool in connection with a kind of classic, I would say, crime. Also, the fact that a crime is not already defined in another international convention. Why should we take time to redefine a crime which has already been defined in an existing international convention? And last but not least, that we can agree on a definition which is sufficiently clear and commonly understood. So that's for criminalization. On the procedural measures, in order to fight cybercrime effectively, there is no doubt that law enforcement authorities need to be able to rely on procedural measures that provide a basis for effective criminal investigations in their countries. The EU therefore supports the inclusion of provisions that provide a basis for such measures in the future convention. The EU has included in its contribution provisions for the expedited preservation of stored computer data, for production orders, for subscriber information, as well as for search and seizure of stored computer data. But we are all well aware that the application of these procedural measures constitutes an interference with the human rights and the freedoms of individuals. The EU contribution includes, therefore, some provisions to guarantee that the establishment, implementation, and application of the powers and procedures are subject to conditions and safeguards set out in domestic laws, which should provide for the adequate and full protection of human rights and the protection of privacy and personal data, which is, of course, very important for the EU and its member states. Well, of course, we have looked attentively at the contribution that other UN member states have submitted, and we saw that there is an interest to include more sensitive procedural measures in line with, for instance, the Budapest Convention. And these are procedural measures, notably the real-time collection of traffic data or the interception of content data, that constitute a more significant interference with the human rights and the freedoms of individuals. Those data are more sensitive, and the measures in relation to those data may constitute a high level of interference with a person's human rights and freedoms. They should be therefore subject to stronger conditions and safeguards. We also note that there is a large interest, obviously, also in line with Budapest, to extend the scope of application of the procedural measures with regard to the collection of electronic evidence, also for crimes which are not defined in the future convention. And as it is, you have probably noticed it, if you have looked at the EU contribution, it is clearly set out at the outset of the EU contribution, we remain open to discuss such an extended scope of application of the procedural measures, and notably for the cooperation on electronic evidence for all types of crimes. But we consider it essential to discuss the level of condition and safeguards that the future convention will provide for the protection of human rights and freedom. And we should ensure that this level is appropriate to allow for such an extended scope of application of the future convention. And that's the reason why it does not appear upfront in our contribution, because we wanted to make it clear for all the UN members that we would be very careful when it comes to those conditions and safeguards. But the EU is confident that appropriate answers can be found to those questions and to this trade-off, which will make it possible to accept an expanded scope compared to what is provided in the EU contribution. I will stop there, but of course, ready to take questions and discuss with the group.
Thank you, Dan. This was really good also to understand some more and get more insights to the submission. And I think it was very useful to have your rationale and these more strategic issues on things that might not be in the submission of April, and how you plan to go about it. And that is actually a great segue to go to Paulina, because I think a lot of the points that Dan mentioned, especially in relation to criminalization and also preamble aspects, are also reflected in your submission, with Article 19 being one of the dozen organizations, non-state and non-governmental organizations, that have also taken the time to submit their own contributions to the process. So I'll invite you to, Paulina, to have a reaction to Dan's points, and also any other key issues that you want to flag as we are starting the process next week.
Thank you, Tanya. Yes, it's super relevant to listen to Ron a bit more about like the openness they may have to other conversations. But thank you very much, first of all, for having Article 19 here. So I am Paulina Gutierrez. I am the Senior Legal Officer at the Law and Policy Program in Article 19. So for those that do not know us, we are an international human rights organization that works around the world on the defense and promotion of the right to freedom of expression. So we have been monitoring and analyzing cybercrime laws for a long time now. And that's why we decided to engage in the process of the ad hoc committee. And it's based on this experience that we are now reacting and commenting on all the process. So in terms of the EU contribution to the ad hoc committee, so I will focus on two key areas. One, particularly on the positive aspects that we already identified, and I think Ron already raised some of them, but also maybe some additional comments in terms of how can we strengthen the human rights protections and safeguards that a treaty of this nature may require. So in terms of the positive aspects we identify, it's definitely the narrow scope that the EU is proposing in this initial contribution, right? Not only in terms of the lists of the crimes that are particularly from Article 5 to 9, but also on the limited scope of application that they are proposing of the procedural measures. As Ron already mentioned, many states are at the outset setting out that there should be application of this convention to all crimes, and not even only just those that involve an ICT or a computer or the use of technology. So this narrow scope, as I said, not only in terms of crimes, but also on the scope of application of the treaty, for us, it's a very positive stand. And even though there may be some open spaces for expanding this scope of application and of the crimes, I think this is a very positive initial position to go and start the negotiations as the EU, particularly also because I think that if we are using Budapest as the baseline and the particular international instrument informing the process, we can also learn from what has been happened during its implementation and the different reservations that already exist on several of these offenses. The only article that we may have some comments in terms of recommendation is Article 10, the one on aiding and abetting, because since the beginning of the existence of regulation of Budapest, we have seen that in different countries the intentionality threshold varies, right? So in this specific crime, although it contains the intentionality in itself, it's different from dishonest intent or malicious intent that you can find in other crimes, and this can eventually lead to some openness and broad interpretation of aiding and abetting the commission of these crimes from Article 5 to 9. So for us, it's important to remember that this intentionality threshold needs to be very high, in particular in this type of treaties. And also, in addition to this, like in terms of adding some layers of protection and procedural safeguards, we also find very positive that there are different and additional references to human rights protections, not only in the section of procedural safeguards, but also since the beginning and on the prosecution pieces of some articles. And that's why also we are thinking that by including some additional protections is important, because it will be, while there are some references, it's important to think about the practical aspects of this. So when we talk about some additional layers of protection and safeguards, we basically have been recommending to consider the inclusion of public interest defense, which can also ensure that there are some legitimate activities in terms of accessing a computer or data access that can be protected under this public interest defense. And in addition to that is also the serious harm that has been identified. We have identified in many national laws that this has been also an issue in terms of the impacts that this crime is having, and how this serious harm and dishonest intent can set a high bar of criminality that can fulfill the necessity test for such a crime that will later be transposed into many national laws. Of course, I may have many other comments on the procedural section, but I will leave our intervention to these reactions, and I will be very happy to continue with further sections. Thank you.
Thank you, Paulina, for being very targeted and succinct and very to the point. I think these are interesting points also for Dan to react and to also engage with the rest in the dialogue. I'll pass it on to Nick Aston-Hart from ICC United Kingdom. You are representing a huge number of companies. I don't recall now how many millions, but that makes you quite an interesting stakeholder also to hear from, as we've seen also you have submitted your own contribution, and Nick would be very keen to hear your thoughts.
Yes, well, and thank you. And I should say at the outset, ICC United Kingdom doesn't represent directly millions of companies, but we are part of the International Chamber of Commerce, which does. We represent several hundred, so it's still a decent number, and they're very diverse and trade globally. First, thank you for hosting this in the first place. More stakeholder involvement, I think, is better than less. And for asking me to talk, it's kind of hard to follow Article 19, but I'm going to try. I would say I agree with what they have just said. Intentionality is important. The EU provides for this, but I think you need intentionality to actually commit a crime. Intent for a criminal act, because you can intentionally break into a computer network because you're being employed by the people who own that network to find out if its defenses are sufficient or not. And even in the United States, the law that they passed a few years ago, not very many, actually still leaves a loophole where those who are defending networks can be prosecuted as if they were criminally trying to break into them. So it has had a chilling effect on security research in some instances. I also agree with them on the threshold should be serious crimes, not other crimes, for many reasons, but most importantly being the amount of work that a national government has to do behind the scenes to create the cooperation internationally on all these crimes, train their detectives, train their judicial systems is enormous. And if we start having even non-serious crimes being subject to international conventions, there's all kinds of conflict of laws questions that are going to come up, as well as a lack of common definition of the crime in question. I think we have to walk before we run, and the EU's very sensibly said we should be focusing on cyber-dependent crimes, because again, there are many other things you could address, but we should walk before we run and make sure that what we intend when this convention is agreed, presuming it is actually what takes place, because that is far from certain in an area this complicated. The other thing I would say is the EU proposal has been silent on this, and to be fair, so has every other proposal that we've read. There's really no acknowledgement of conflict of laws problems. Production orders are just, you must produce this documentation, you must produce this evidence. And I think the EU experience here would be really salutary in doing some side events or something for member states to understand the process of national convergence to get to the point where there are arrest warrants across Europe, especially in the cybercrime field. I don't think many delegations understand how complicated this really is to do in an effective, human rights-centered way. And the European experience, I think, is something that many countries would value. But there are already many instances of companies being asked to produce data from country A. Country A asks for data, they're located in country B, and it would be against the law for them to provide the data in either the extent that is being requested or in regards of the specifics that are being requested due to a legal issue in country B where they are headquartered, or even worse, the data may not be held in either the requesting country or the country the request is being made to, but in a third country. And this is particularly important with data protection. There are all kinds of situations where an EU headquartered company would not be able to produce certain kinds of data and hand them over to a third party outside of the EU without running a legal risk. And I accept that the idea in implementing a convention like this is that the states involved behind the scenes would ensure that these kinds of frictions are addressed, but I think we know in practice that doesn't work well even between highly converged economies with long histories of common legal traditions and judicial cooperation. I think also the EU could do something useful in asking for an analysis by the Secretariat for all the crimes that are being proposed by all member states for inclusion in this. Where do those crimes actually exist in national law, and how commonly are they defined? Because we're seeing proposals for inclusion of crimes that are not even crimes. I mean, you know, copyright infringement is the most obvious one. This is not a criminal infringement. It's against the law, but it's a civil penalty-based system. And so I think if member states understood how few jurisdictions have common implementations of some of the crimes that they're proposing, it would considerably help to limit the very expansive calls we are seeing from some countries for very broad criminalization. So I would say those are the I have some comments on the specifics of your proposal, but I won't go paragraph by paragraph. I'm happy to email them with some thoughts that we had. So I think that's a good sort of flavor. And I thank all the others who contributed written proposals to the written statements from the non-governmental sector. I read them all, and our contribution to the second session, I actually name-checked several of the provisions that several of you proposed because we thought they were really good.
Great. Thank you, Nick. And actually great to also have very concrete practical suggestions that they can be potentially taken over as also a means to raise awareness through an analysis by the Secretariat, as you mentioned. And I want to hear also from Nena, bringing a bit of a different approach, from on the one hand, being an academic and a senior lecturer in law and technology at the Hillary Rodham Clinton School of Law at Swansea University, but also vice chair of the African Union Cybersecurity Experts Group. So you are kind of bridging both the academic, but also in a way the practitioner's world. Nena, some of your reactions before we open the floor to the rest.
Thank you, Ine, and thanks to Dan, Nick, and Ponina for the elaborate responses to the contribution. I think they've said so many things, and I'll just add, I will particularly differ in terms of the notion that, the convention should be narrow in scope. For me, yes, that's an argument by many countries, but I worry that a limited convention with a narrow scope may not necessarily go beyond the Budapest Convention or what the Budapest Convention is doing, and it may duplicate or undermine efforts. We've seen different terminologies: cyber-enabled, cyber-dependent, crimes that target ICTs, computer crimes. What is the difference between computer crimes and, cyber-enabled crimes? And while states are apprehensive about broad or expanded scope or having a long list of crimes, there is also the need to understand that there are many aspects that will be a challenge if they are not addressed now. For example, copyright infringement can be civil. In many jurisdictions, it is criminal. At the same time, we have to think about issues like criminalization of the laundering of proceeds of crime. There are many aspects, thinking about issues. If we are arguing that it should be technology neutral, at the same time, we're arguing for it to be narrow in scope. So how then does it play around technology neutrality at the same time if it is narrow in scope? We may have to come back later and it presents a challenge. So it's also important to address the question of whether technology indeed represents a neutral artifact. We must remember as well that physical technologies themselves may be neutral, but yet they are subject to values of power holders. And so I also want to add that, the convention and even the contributions, I appreciate the EU for that contribution, it sort of reflects the working title. And when you look at some contributions, you find that they do not necessarily reflect the working title. There is also the need for conceptual clarity, and I think that should be added in terms of the contribution, because the use of terminology would also impact on certainty, predictability, and legitimacy. And I say this because I'm from the African region. If terminologies are not clear, it may be a problem. Impressively, the EU's contribution also captures jurisdiction. And this is something that must be lauded, reflection of Article 22 of the Budapest Convention. However, jurisdiction has to be addressed appropriately in relation to international cooperation, or we may see a continued resurgence of the digital sovereignty narrative with the convention when the work is done. The understanding of digital sovereignty in the global discourse of digital policy still needs an interrogation of the definition, the drivers, and the significance of the concept. I also say this because traditionally, territoriality in terms of jurisdiction is defined in terms of borders. And how do we define jurisdiction in terms of computer networks? Cyberspace is not tied to any geographically proximate location. And so while we talk about jurisdiction, I think that provision or that contribution can be expanded to touch upon issues of digital sovereignty. So much has been said about human rights. I want to touch on that. Again, I laud the EU for taking the step to mention victim protection. There has been so much being said about cybercrime. Sometimes I say states make it about themselves. It's become a state issue, and yet there are victims. And that's a reflection of Article 25 of the UNTOC, so thanks to the EU. However, another instance I want to bring up is that, we need to also consider that justice is a three-way process. And I think Nick touched upon the issue in relation to, accused persons and procedures. Justice is not just for the victims or the state, but the accused. And so this goes to the contribution regarding criminal procedures and law enforcement. It is important to be clear in terms of standards of investigation and prosecution in relation to accused persons. And this also touches upon human rights. Even though we are calling for provisions that are technology neutral and address not only present day technologies and criminal techniques, and this call for a general definition to encompass crimes, it is important to also ensure that a definition of crime within the convention shall be strictly construed by states and should not be extended by analogy. And I think we can make that clear. It is important that the convention is drafted in a way that in the case of ambiguity, the definition will be interpreted in the favor of the person being investigated, prosecuted, or convicted, or states in certain regions may take advantage of that and hinder human rights. It is also clear that states understand that just like criminal laws, prosecution of cybercrime should also allow for grounds that exclude criminal liability. And, Nick touched upon intent. So we must also think about mistake of fact, mistake of law, and having, the convention couched as if states may require that intent. Intent is primary, and it shouldn't be something that, should be a basis of pick and choose. I just want to add another issue in terms of cooperation, capacity building, technical capacity. We see that resonate all the time, capacity building. Domestic capabilities and skill sets must be, considered. I don't know how that can be worded in the convention, but many times you find that international standards collide with realities of developing states because they are at the end of the divide, lack of digital capacity and skills. While we think about digital capacity, we think about capacity building, I think responsibility and accountability is core, particularly for places like the African region. How it can be worded in the convention, that is something I didn't particularly see in the contribution. I know the EU is huge on capacity building for regions like Africa. It is important that we voice a need for a mechanism to ensure accountability and responsibility and see how the convention is implemented. Lastly, multi-stakeholder approach. That is something, again, I didn't see in the convention. Of course, it was tailored well, but it is important that the convention mandates, and that is something I like about the Malabo Convention. I can brag a bit about that. In Article 26, talking about states undertaking to cooperate with multi-stakeholders. I think that should be mandated, or else certain regions as well may exclude diverse stakeholders, and that would not create an opportunity for an appropriate balance to monitor human rights as has been voiced. I'll stop there because of time. Thank you, Nia.
Thank you, Nana. That's a really important points, and you raised also at the end the capacity building aspect, and of course the multi-stakeholderism. I want to invite anyone who wishes to take the floor from the participants to either use the raise the hand functionality, and I can give you the floor, or just type your interest to express your views in the chat, and then I'll give you the floor, and just identify yourself, your name, your organization, your affiliation. As I see many of you are quite shy, in the meantime, I see, okay, I actually, you're not so shy. So I see two people. Maybe very quick reaction from Dan, 1 minute or so on these points. If Dan, these are some of the issues that you have that they have been raised until now that are of interest, that it's something to internalize. And they align with the approach that you have, and maybe to give you some more time to think, because I caught you a bit maybe off guard on this. I'll give the floor first to Anastasia Kazakova from Kaspersky, and then Nemanja Malisevic. So Anastasia, the floor is yours.
Thank you very much also for convening this session, and also for sharing all photo inputs. I think this is really, really helpful, especially for those who are just also learning about the entire process within the UN context. I have a question to the European Commission representative. This is really helpful to read the submission done in April by the European Commission, also because it outlines clearly the scope of applications. I think for the cybercrime treaty, there's a lot of expectations perhaps from the industry partners, largely that the new treaty may actually ease the international cooperation component. But I haven't seen, and sorry if I'm wrong here, I haven't seen the particular more clear provisions in the European Commission submission about the international cooperation component. So that would be really helpful if any further perhaps input could be shared. How do you, from the point of view of the European Union, that the new treaty that could be negotiated within the UN could actually contribute to the more easier international cooperations to fight cybercrime. Thank you.
Thank you, Anastasia. I'll keep them so that we have a bit more time for questions while, before passing it on to Dan. And Amaya, could you please take the floor and identify yourself, your affiliation?
Sure thing. This is Nino I'm the Director for Digital Diplomacy at Microsoft, and we've been actively following this process. We very much welcome this convening today. As you know, we've been active supporters of involving multi-stakeholders in this and all other UN discussions. So thank you very much for bringing us together here. We've submitted a longer position, and I look forward to being on the ground in Vienna for the next 2 weeks. So I'll limit my remarks today basically on the provisions on criminalization, but we have views on all the others. Overall, I feel we're broadly aligned with the EU position. So again, thank you very much for the work that went into this. I do want to follow up on a couple of things that Nick also mentioned, and in that we strongly believe that the convention should criminalize only substantive offenses that are cyber dependent. I think that is really something that we feel very, very strongly about. I feel the intentionality point that Nick mentioned, just to reiterate that from an industry perspective, is really important, because again, you do not want to create a situation where security and vulnerability researchers are put in difficult positions. Related to that, again, that the convention should not treat traditional crimes as cybercrime merely because a computer was involved in the planning or the execution of the crime, and obviously to also stay away from criminal offenses that are already adequately covered in other existing treaties, whether that's terrorism-related offenses, arms trafficking, and whatnot. I feel we also very strongly believe that the convention should not attempt to regulate content. So I feel we're also aligned in this on this point. And again, I think we very much reiterating the point that Nene just mentioned. We are very aware of, I feel, also not just the role, but also the responsibility that the multi-stakeholder community has in these types of negotiations and conversations, to kind of bring a perspective or a real world perspective to some of the talks that are happening. So we very much look forward to being part of these ongoing conversations, and I look forward to hopefully seeing many of you in Vienna next week. Thanks.
Certainly, thank you, Nino. Dan, I will give you the opportunity to have a reaction to some of the points raised already, and also invite others to join in a second round shortly. So again, raise your hand or write in the text tab. Over to you, Dan.
Thanks, Naya. Okay, I mean, there were not necessarily questions. I mean, one clear question and a clear reply to that question: why the EU contribution does not include the provisions on international cooperation? Simply because, as indicated at the beginning, of course, this session focuses on 3 chapters only, which does not include the ones on international cooperation. The chapter on international cooperation will be dealt with at the 3rd session in New York, end of August, beginning of September. And therefore, there is only a reference to international cooperation in our contribution when it comes to the scope of the convention, and where we make reference to the cooperation on electronic evidence. And that's why I mentioned that, which is of course one of the key elements of international cooperation, but which in the structure that we had in mind was already reflected in those chapters. But the more detailed elements of the chapter on international cooperation should be provided in the contribution, and I think that the deadlines that have been provided by the chair to the UN members for those contributions is the 1st of July. So in fact, very quickly after at the end of the 2nd session, we'll have not such a lot of time. Yeah, for the rest, I heard with interest the comments made by the other speakers. on the seriousness of crime, on the fact that the convention should cover only serious crimes, I think this is an interesting indeed criteria which could be added to our kind of EU list, because indeed, I mean, I don't think that members can afford to focus the work of their law enforcement authorities on well, petty crimes. Let's say the international cooperation should focus on the crimes which are the most serious. Obviously, again, does that mean that all crimes should not be adequately fought and prosecuted? But yeah, when it comes to international cooperation, it would make sense. Yeah, I think I will stop there to make sure that more questions can be, or more comments can be made.
Indeed, I see two more hands, Raman from Access Now and René Sommer from Ericsson Group. Raman, can you please start, and then I'll pass it on to René.
Thank you so much, Naya. And firstly, thank you for organizing this. This has been super helpful. I think beyond just reading the actual submissions, getting a sense of how actors are looking at this and the difficult issues that are coming up are quite useful. I'm Senior International Counsel and Director for Public Policy at Access Now, based in the Asia Pacific region. I also cover our work in global cybersecurity and will be there in Vienna for at least the first 10 days. So hopefully see many of you there in person starting next week. I had a question, in fact, specifically on, I know the challenges coming on the issue of cyber-dependent and cyber-enabled crime. And we appreciate the strong position taken by the EU saying that we must focus on cyber-dependent crime for the treaty. But I also noted that you mentioned that you left some space for negotiation on critical cyber-enabled crimes that might be included. And I'm just curious here if the EU was considering the approach on dual criminality that was there in parts of the UNCAC and the UNTOC, the Transnational Organized Crime Treaty, where legal assistance on dual criminality issues was sometimes there. It's an issue we've also been trying to grapple with from Access Now. Is that an effective alternative for states that are very keen on ensuring legal assistance on cyber enabled crimes? Is that sort of limited scope possible? It goes to Nick's point as well, that if states do actually criminalize the same activity domestically, can the treaty help enable perhaps cooperation there? Just curious if that has been an area of EU thinking, if that's something you might use as states come to you, perhaps pushing more on cyber enabled crimes. And just lastly, just to thank for the strong focus on protecting security researchers that Nick and others also mentioned. We believe that's critical that the cybercrime convention process doesn't make us more cyber insecure, and we hope that approach continues there, including from the EU. Thank you.
Thank you, Raman, and points taken, and also many thanks also for the Access Now submission that also delved into these issues. I'll pass it on to René. I see you have your hand raised.
Thank you very much. I'm trying to get my camera on. I hope it is working. So thank you again for the invitation. And actually, just like say that I'm actually speaking on behalf of ICC International and not as Ericsson. So referring to Nick's comment about the international organization, the umbrella one, I put in our chat 2 links to our issue brief 1 and 2. And what I would like to raise is on top of those important messages that have been already conveyed and the balance that we were discussing. But we have also, of course, seen that the cyberspace has moved on. And this is not in relation to the content crimes we were speaking of, but we have seen, and we talk about that in the issue brief 1, the explosion of cyber-enabled crime, if you want to use that word, which doesn't maybe work well in this context. But the point is being that we see an increased criminalization and commercialization of cyber-enabled tools. So we see different stakeholders who are in the system developing or sharing offensive cyber tools. This software is developed with the purpose to create harm. And this is happening today significantly in the dark web. And there's enormous inflows of those cyber offensive tools, and they grow by the day with hundreds of thousands every day. Secondly, we also see facilitation of that dissemination of those tools on the dark web by different stakeholders. And lastly, also we see a development of mechanisms to actually get paid and reimbursed for the service. So we see also that there is also activities being enabled by stakeholders who are actually making money on this. So in principle today, you can be a young person with very low skills, and you can today acquire for very low cost by using cryptocurrency equivalents of tanks, but in software sense, you can access those, pay for those, you can get a manual, even a call center that can help you to execute the software. And this is happening every day. So the point being here, would also like to raise the point that we have seen this development, and whether there would be scope within the European Commission and other stakeholders to consider this development, and to what extent this type of activities or parts of these activities could be considered to limit the dissemination of this kind of offensive software, which is put in place for one purpose, and it's put there for profit, and it is supported through various means to allow a very low skill, at low cost, anyone to execute those softwares. So I would be very keen to hear what others have to say about this, and whether there is room to have a discussion, whether this could be part of the deliberations going forward. Thank you very much.
Thank you, Rena, and it's an interesting point also to see if we have others picking up on this. I want to give an opportunity for any other intervention, as I see we are, we have 5 more minutes in this, and I hope it was helpful to hear the more insights on the EU position, but also for everyone to hear the analysis that we had, and take it from here also throughout the second session, but also in the run-up to then the third session, as also Nastia mentioned the international cooperation piece, which is quite critical for the next one. I don't know if I don't see anyone with anything burning to say, so I want to give also maybe the opportunity in case Paulina, Nick, or Nena have anything further to say before passing it on to Dan for a quick reaction to Raman's point about your consideration of potentially dual criminality. Nick?
Yeah, thanks. I would just very quickly say I certainly agree with the points that were made about the importance that the crimes in the convention are actually recognized widely as criminal acts very broadly across UN member states, because there won't really be any cooperation on crimes which are not crimes in a very wide number of jurisdictions, and which are not defined very similarly or compatibly, at least in many jurisdictions. I think this is actually to our benefit, because it helps to avoid a lot of content-related crimes, which would be violations of freedom of expression in many countries in the first instance. But that's part of why I was suggesting that analysis be done, is there are plenty of things you could criminalize, but they're not widely recognized as crimes, so you can't really enforce anything, and you're not going to get any cooperation on enforcing them. And so I just figured I'd add that final point.
Thank you, Nick. And indeed, it ties up well with what was said until now. And Dan, maybe your 2 cents briefly on the question from Raman about the cyber-enabled clients and the EU's potential strategy regarding dual criminality in that space.
Yeah, I mean, I fully agree with what Nick just said, by the way, and on the point made before, those software which are developed for, to produce for malicious purposes. In my sense, this is covered by the Article 9 of the EU contribution, Uses of Devices, which reflects, of course, the Budapest provision, where the production, sale, procurement for use, import, distribution of a device, a computer program, designed or adapted for the purpose of committing any of the offense should be criminalized. So to me, it's covered, but perhaps I've misunderstood something, and there is another element, but I would assume this is covered. On the question on dual criminality, I'm not sure I fully understood the question, I have to say, but if the point, I mean, obviously, normally in the added value of having a crimes defined in a convention is that there is a common understanding of this crime, and the crime is then universally, or at least is recognized as a crime by those who have joined the convention. For those crimes which will not be defined in the convention, but for which international cooperation would apply, for instance, if there would be agreement on extending the scope of the cooperation on electronic evidence to all types of crimes. Here, of course, there will be the conditionality of the double criminality, because one country is not going to cooperate with another country for a crime which is not recognized on its territory. That is obvious. But again, perhaps I've misunderstood the question because it was very quick, I have to say. So, but that was my understanding at least.
Thank you, Dan. And indeed, also in case we can check in with Roman, that will be, I think many of you will be there next week or also the week after, as the EU delegation will be there. And on that note, actually, I want to pass on the floor to a face that is, I trust, quite familiar to many of you, has been building this multi-stakeholder engagement also on other cyber-related aspects, like the open-ended working group. Helen Pope from the European External Action Service to give some closing points and maybe reflections for next steps. Helen, the floor is yours.
Thank you, Naya. And thank you to all who joined us here today. I personally very much enjoyed this short exchange and absolutely see a value of making this format the regular one, to meet, for example, before every session, if not more frequently. And I think the first order of business needs to be that we need to make this meeting a little bit longer one, and also maybe around certain areas or topics, so we can dive in a little bit more. But there were several points that I took away from this session when it comes to potential side events or the existing gaps or even capacity building. So there's a lot that we have to discuss as we go forward. But since we are short of time, let me just say that I'm looking forward to meeting at least some of you in Vienna. Please don't hesitate to get in contact, and same goes, of course, to all others. And thank you again, Naya, for bringing us together here today.
A big thanks from my end to all the speakers and for really the insightful points, and for taking the time, Paulina, Nena, Nick, to also delving into the EU position, your proposals, of course, to Dan for giving us a bit more or maybe much more than what is in the submission in terms of outlook, and big thanks also to the team at EU Cyber Direct for putting this together, Patrick, Agnes, Niels, that many of you know, hoping to see many of you in Vienna, and looking forward to facilitating further such dialogues, and from learning from this, maybe having more time and arranging several interactions like this throughout in between the sessions. Have a lovely afternoon, rest of day to wherever you are, and keep safe, and bon courage with all the preps for Vienna. Thanks to all.